Pleasure to be here. Appreciate the opportunity to speak to this. Okay, so first.
So if you don't know, this is Bryan Bertram. He is the town council. He works for Harrington Heep. That's our outside counsel for Hopkinton. Bertram, you'll notice him, or you may have seen him at town meeting. He will sit next to Connor Deegan, the town clerk, up on the dais to make sure that procedurally everything is being followed appropriately. So he's here tonight at the request of the select board, and specifically select board member Joe Clark, who has asked for an update on where the town is at, or what happened essentially with the release of the improperly redacted transcript with respect to Deputy Jay Porter's alleged rape victim.
Is the volume good?
Should be good.
Okay. All right, so the way I view this is I'll give a short presentation, and then to the extent the select board has any questions, you can ask those of me at that point. Does that make sense?
Yeah.
Okay.
You'll let us know what questions you can't answer and things like that, and you'll keep us in line.
I'm very, very good about telling you when I can't say something, but the good news is we'll get into it. We have a report here from an independent authority that we can refer to, and there's a lot we can discuss.
The report he's referring to is the report of the investigation from the Northwest District Attorney's Office, specifically DA Gagney, who did an investigation subsequent to the release of the transcript. And Bertram will get into that in a minute.
As I prepared for this tonight and thought about where we should start, personally and really on behalf of the team, I just want to start with an apology. I personally feel awful about what happened, and I know, having spoken with all of the team members, that they do too. I helped draft the written statement we made afterwards, and this was a mistake, and we feel poorly for it, and we do need to apologize for that.
So this is the first time, this is important because this is really the first time anybody has publicly said, we're sorry. After the release happened at the next select board meeting, Muriel Kramer, who was the chair at the time, did apologize to the victim from the select board, but it was kind of we need to look at this to make sure that it never happens again. This is the first time a full-throated apology has been issued to the alleged victim / survivor. So it's important that this was said.
I can't pretend to say I understand how this affected the survivor because I'm not in her shoes and I don't know. But I certainly appreciate the significance of it and the severity of it, and we get that. And I think that being here tonight is an opportunity to both apologize and, probably more importantly to everybody, to sort of start with sort of what happened, address how we're improving our process, and then field any questions that you may have. But there's just no other way to start this than with an apology. And so I do want to offer that on behalf of myself personally, as well as the folks that I've worked with. As everyone is aware, after this happened, I know there were complaints from third parties that went to the Middlesex District Attorney's Office. I can also tell you that very soon in time after this happened, behind the scenes, the team actually also reached out to the Assistant District Attorney who's handling the Jay Porter prosecution to make sure that we also disclosed it independently to the Middlesex District Attorney's Office.
So that's new information. Essentially, Bertram saying that as soon as they understood or learned that the transcript had been released, that they called DA Ryan's office in Middlesex County to say, hey, this happened, what do we do now? And as we know, what happened at that time was the Middlesex DA referred that to the Northwest District Attorney's Office, which is way out in Western Massachusetts, because the Middlesex DA couldn't investigate this because they already had the Jay Porter indictment pending. And so they couldn't get involved with this. So what they were looking to do was try to find a way to get somebody who's not involved to take a fresh look at it. But what we didn't know is that Harrington Heep had actually made the call to the Middlesex DA.
And as you know, that resulted in a referral out to the Northwestern DA's office. For all of those who aren't familiar with the different district attorneys, they're way out west in Massachusetts. And that was a good thing, because one of the things when this mistake happened that we needed to evaluate was, how do you look into it, but how do you do that in a way that's independent of the people that were involved? And so I think that referral was a good thing, because it got us to an authority that's in no way connected with the town. We don't pay them, we don't direct them. They are an independent authority who looks into these matters, and they did so. And they generated a report, which is available to the public, dated April 17th, 2024. One which everybody internally in Hopkinton cooperated with without reservation. No one avoided that, and which really sort of lays out what happened.
That report is available on Hop News, and we'll include that as a link in this article as well, just for those that, just to save you the search. But we reported, when the report was released, we reported on the results of the report, and we also included the full PDF of the report.
Which again was certainly not intended, and it was a mistake, and it resulted from certain failure points in the process that we've looked at, we've evaluated, and that we're trying to correct. Because this is both a significant matter to first to the survivor and to the prosecution of the alleged crimes, to the town, which has an interest in how its government is functioning.
Yeah, that's true, but it's a significant matter to the town because the disclosure of this information opens the town up to, an untold sum of liability that no doubt the town's insurance will have to kick in for from a civil case, essentially, that the alleged victim can bring for essentially saying, you violated Massachusetts general law, you disclosed my personal information, that is it's a straight violation, it's admitted, it's provable, so yeah, the town has an interest in its government functioning better, but the town also has an interest in not paying millions of dollars out for what was an avoidable mistake.
And frankly to us, because we expect more of ourselves in the service.
Yeah, and to you, because now that you've admitted that Harrington Heep has admitted that they did this, that they're open to liability as well.
That we deliver to the town. So just to go through it briefly, the document in question was not the report of the investigation, it was the transcript of one of the interviews that supported it.
That's true. That was a transcript between Daniel Linsky, who was the lead investigator for Kroll Investigative Services, who was subcontracted by Harrington Heep, and Sergeant Timothy Brennan, who was at the time on administrative leave, and Kroll Investigations was attempting to ascertain what Sergeant Brennan knew about the alleged victim and her interaction, or I suppose the crime, the alleged crime between her and Porter, and when he knew that, and why he didn't disclose it. And just to set the table and remind everybody, when Brennan knew, this is a matter of fact, what I'm about to say is a matter of fact. When he knew, the victim was 28 years old. She was not a minor child. He did not know contemporaneously, he did not know when the crime was occurring, and he did not go to his superior officer to disclose what he knew. His superior officer at the time was Deputy J. Porter. So he instead urged the victim to come forward and report it on her own. So the transcript that he's talking about is the transcript. It's about 89 or 91 pages between Kroll and Brennan.
Of the police sergeant in question. And in the course of that interview, is the standard investigatory practice in those. Actually, sort of the ground rules is you weren't supposed to refer to anybody by name. That's sort of like the first line that you follow so that you can avoid mistakes in the future. But we're all human, and so I think the investigator and the sergeant may have slipped at one point or another.
That is factually inaccurate. If you read the transcript, you will see that, in fact, it was Linsky that said the victim's name, not Brennan. So The way Bertram there says, well, they're all human, maybe they slipped and maybe they said it, that spreads the blame around. That's not true. It was the investigative service that said her name. It was the investigative service that improperly redacted the transcript, as you'll hear him tell you later. It was not Tim Brennan.
Trying to put blame on them. We're all human, it happens.
No, it doesn't happen. This doesn't happen. And when it does happen, there's a law to prevent it from happening. And there are consequences to that law, and it's spelled out.
That's how it ended up in the transcript. This was being done by an independent investigation firm, which is standard when we do these things, again, for a level of independence separate from the town. Before they delivered it to the town's labor council, they actually had the transcript redacted. And so when we received the transcript, it already had been redacted insufficiently, as it turned out, but nonetheless redacted. And so I know the first copy that I saw and the first copy that anybody on the team saw actually had, I think, 16 different redactions across what was a pretty lengthy document, 81 pages of substance in the interview. And
okay, so that's probably true, what he's saying, but it's important to note that as the town's attorney, that firm, Harrington Heep, is responsible for redactions. And we know this because HopNews frequently does public information requests, and frequently we will see redactions made by Harrington Heep. So the fact that Kroll had done some redactions and sent it before they sent it to Harrington Heep, sure, that probably did happen, but that does not absolve Harrington Heep of the responsibility of ensuring that whatever goes out is properly redacted. That's on the town's attorney to do, not the investigative service that they subcontracted.
11 pages in the index. And so, the process, for that Loudermill hearing and everything went forward. As the Northwestern District Attorney's Office report spells out, many people had access to this document at many different times. But they're also doing it for different reasons. Just because, for example, the select board may have received it doesn't mean there was a responsibility there to identify redactions or anything. We do it for different processes. There are opportunities maybe to notice it, but at the...
this is the part that is completely ponderous to me, because I read the document, I read the unredacted document, and I immediately noticed, because I read every single page of it, that the alleged victim's name was in there and not redacted. So every single select board member received a copy of this transcript in advance of the Loudermill hearing on January 19th. And presumably every single member of the select board read it. So Bertram's making the point that, well, everybody reads it for different reasons, but the fact is if you were looking at this, if you're just a regular person looking at this, you would see that and go, wait a minute, that shouldn't be there. Why am I seeing a name that shouldn't be there? That would be a normal human thing to do. So I'm a bit perplexed, not by what he's saying, but by basically the omission that everybody received it in advance and just didn't look at it and just didn't notice it. That part just doesn't make sense to me.
The day, even though it's circulated amongst people, you still need processes to redact this. And it was, in fact, redacted or reviewed for redaction by a member of the legal team.
A member of the legal team that works at Harrington Heep. So what I infer from that, and he gets into this later and he says, somebody on my team should have caught it. This is the part that I don't understand. This is the most consequential, very likely the most consequential case that has ever come before the town. We're talking felony rape of a child, multiple counts by a town employee, a police officer at a school, and you're telling me that an associate on your team, not you, was the one that was responsible for ensuring it was redacted? That seems like a misalignment there. Our town council, Bryan Bertram, is the one who should have had eyes on this. This is the most important document, one of the most important documents that'll ever come to the public light. And he's saying that an associate on his team was the one responsible for that. I don't understand that at all.
who obviously thought that it had also been previously redacted by somebody else at the investigative firm. I think as the district attorney's report actually reveals to us, it was by the transcriptionist and was not reviewed further there.
So in other words, the person who was transcribing it, a stenographer, a secretary, whoever the transcriptionist that was sitting in the room while Linsky interviewed Brennan, is the one that they said, or that they assumed had redacted everything. I mean, that's just wrong. That's just wrong, and that's an insufficient level of care and it's an insufficient level of professionalism, candidly.
So, that again is a variable that went into the mistake that happened. Maybe a false sense of thinking it had been redacted or reviewed for redaction more times than it had, with more eyes on it for that, and also because it had been circulated to the team. But in any event, there was a set of eyes on it to review it for redactions, and the name was missed, and it shouldn't.
It was more than the name. It wasn't just the name. He says the name because that's the way the MGL reads, is that you can't release the name of the alleged victim, but it was more than the name. It was also the college she went to. It was also the birthdays of her kids. There was other information in there that in a town of Hopkinton's size wouldn't have been hard for somebody to put together who the alleged victim was.
Missed, but it was. And so as we went towards the Loudermill hearing, the circumstance that we faced is that typically Loudermill hearings, it's not a legal rule, but by practice, are usually done in executive session. That's the way the parties want it to be done. In this case, however, as was his right, and something he could choose to do, the sergeant wanted to do it in public.
Boy, you can just tell how upset he is that Brennan chose to do a public Loudermill hearing.
The consequence of that is that anything that the select board considers during that hearing becomes a public document. And so in this case, one of the documents that was considered was the interview transcript. There's, in these kinds of cases where there's a significant amount of public interest, we always are concerned about transparency.
That is disingenuous, to say the least. There is a lot of public interest in a lot of things that come before the town and the select board. The town is, I would say never, but rarely proactive in releasing information without a Freedom of Information request being submitted. In fact, I can't remember a time, other than this time, where the town has put out a press release saying, here's a tranche of documents that you just might be interested in because it's in heightened public interest. And when I say that, I'm including the Eversource LNG debacle that only came out after there was, several stories in Hop News about what a disaster the security is at that plant. The town has never been forthcoming just because they were trying to do the right thing. So I don't buy this at all, that this was really the basis for them wanting to disclose all these documents. I don't get it. It's just uncharacteristic for the town.
So, in this case, the decision was made because of those pressures that, rather than wait for the public records law requests that we knew we were going to get and that we would have to comply with because these are public documents.
Which, of course, if they had responded to a public records request, they would have obviously looked at them before they sent them out, and they would have probably redacted it appropriately because that's what they do. That's part of their process. But instead, they just threw it out there for every media outlet in Boston and the greater Metro West to get. And then they sent a press release that said, hey, media outlets, we've released all these documents. And then Select Board member Amy Ritterbusch amplified that on her social media following to thousands of people. So it wasn't just like, oh, we've put these files out on a web server. It was, we put them out and we've sent out a press release. They couldn't have invited a more calamitous result.
An effort would be made to take that package in redacted form, which again was insufficiently done as to the one document, and proactively put it out so that people didn't have to ask for it, that they could have access to it immediately after the decision and could see it. This is in part informed by the town's experiences in some other high-profile matters a few years ago, where we fully complied with public records law obligations, but there was a sense that we could have been more forthcoming about things that happened. And, we were trying to take the lessons from that to do a better job.
I don't know what he's referring to here, and I invite any reader comment to, if you know what he's referring to with something that happened a couple of years ago and they responded to the records request and they were trying to do lessons learned from that, then, let me know, because I'm confused.
I think, as we'll discuss here in a little bit about ways we may improve our processes, in high-profile matters such as this, where we have very sensitive documents, that balance may need to go the other way. We may want to really not follow that approach, because if you do make a mistake, it's out there. And you really can't claw it back in the same way than as if you had just provided it to a single requester and you reached out to that person, and then everybody else who got it would have the correct version.
Right, because they sent it to all of the Boston media, and the first thing that Fox 25 did was they copied down the PDF and they hosted it on their own web server and linked it to their own web server, because they probably saw it and they were like, wow, they're probably going to rip this down once they figure out what they've just sent us. So they couldn't claw it back at that point. It was out there.
That is something, that is one of the things that probably made this worse than it otherwise may have been.
It certainly made it worse.
In any event, that's essentially why it went out in the way it did. There was no other motive other than knowing that it was a public record as of the hearing, that we did want to be as transparent with the public about not just the deliberations that were done in public, but all.
When he says no other motive, what he's trying to do is get out in front of the idea that the documents were released as a form of retaliation against Brennan, and I guess by proxy, the alleged victim, for making a scene out of this whole thing, by making the Loudermill hearing public. That's a theory that has been floated by several people at Public Forum, and also, of course, in the comments of HopNews and Facebook and stuff like that. But and I don't know that there's any basis for that. And he's essentially saying, no, that wasn't the case. We were just kind of trying to do the right thing, getting out in front of this, and we screwed up.
The supporting materials that supported that decision. And in retrospect, because of the mistake, it had a consequence that, it had a severe consequence for the survivor, one that should not have happened. And, that was on a Friday. I became aware of it that Saturday when I spoke with the town manager, and we immediately moved to try to correct it to the best of our ability. This was not.
All right, so he moved to do that, but the reality is the documents were up as of Sunday night. So it was Friday night at 5 o'clock through Saturday, all the way through Sunday night. That's how long it took them to rip them down from the web server.
A problem that was being dealt with in normal business or working hours. It was a problem that we immediately tried to move to deal with as best we could, given that the damage had already been done. So, following that, there's limitations on what we could say and when we could say it, particularly when the Northwestern District Attorney's Office took this up. When they're interviewing people, when they're doing their investigation, they ask that we not discuss things, we not sort of affect what's going on there.
So HopNews clarified this with the DA. They did ask that they not publicly comment on the investigation. When I say they asked, that NWDAO asked the select board not to publicly comment. They did not say that the select board couldn't take some kind of action. For example, with respect to Chief Bennett, they could have taken action. So the idea that their hands were entirely tied isn't true, but they did say, the DA did say to HopNews that they had asked the select board not to sort of meddle in the investigation while it was ongoing.
And I know it creates a level of frustration for the public and everybody else that we're not speaking to it, but we really were trying to respect the wishes of the Northwestern District Attorney's Office, as well as, if or when it is time to speak to the public, and this is certainly the time, that we do so in a comprehensive fashion rather than sort of piecemeal. You know, whether right or wrong, I don't know the survivor's perspective or not, but internally...
Well, if he'd been paying attention to public forums since January, he would know the survivor's perspective, because Timothy Boyven, a resident of Hopkinton, has appeared at every single select board meeting demanding that they hold somebody accountable for this. And he is a personal friend of the family of the survivor. So it wouldn't be hard to understand her perspective. He has talked about the tremendous emotional impact and toll this has taken on her and her children. She's afraid for her life. It's awful. What has happened to this poor woman is awful.
You know, once the mistake is made, at least as a team, we want to address it and be transparent about it, but we don't want to keep repeating it in public and creating a new news cycle on it, and in a way putting a spotlight on it that, you know, I mean, again, I don't know how she views it in her shoes, but at least in my sense, I don't want to do anything that arguably could make it even worse. And repeating it or putting repeated spotlight on it, particularly with an outstanding investigation or not having a complete and comprehensive way to explain it, would maybe not be the best way to go about it.
So what he's saying is, we've waited 6 months to apologize because we didn't have the full facts of the matter in front of us. That is ludicrous. What is substantially provable is that her information was released. What is substantially provable is that that information was released by Chief Joseph Bennett, by the PR firm, by Amy Ritterbusch on the select board. Those are all things that, regardless of how it happened, they don't change anything. The town could have months ago done something to apologize, to do, I mean, they could have just done anything to try to address this with the victim. Instead, they basically just did nothing and said nothing. And this is the first time you're hearing about it from somebody, only because newly elected select board members came in with a mandate to get to the bottom of this, because the residents of Hopkinton who have showed up week after week at public forum are upset, and they want to know who did this and what are we going to do to make this right for this poor woman. That's
sort of the, you know, just basically walking through it. I think that the only other thing that I would add is that I had a number of conversations individually with board members, past and current, about this as it unfolded. You know, even though there was not public sessions, there was certainly an interest, not just by the core team that was responsible for doing this, and I would put the select board aside, you don't review things for redactions, but in figuring...
No, but they're humans, and they review things for common sense, as I said before, so they probably should have seen it.
Why it happened. That did happen, and there was a tremendous level of angst and regret over what happened. You know, in terms of identifying how do we address this? How do we prevent this from happening again? You know, I've heard a lot about, you know, creating a policy. You know, yes and no. I mean, the town handles many documents that are...
There's already a policy for this. You know, this field has been plowed. When somebody requests something, or we as a town are going to send something out publicly, we review it to make sure that it doesn't compromise anything sensitive to send it out. This is just really a normal part of doing business. It happens every day. So I don't understand why it's we got to come up with something new here.
And we've done so in other high-profile cases. It's really, you know, saying that this is a case that's subject to a policy is almost to do it an injustice. This is one of the most significant events. You know, put aside the mistake, just events with the alleged allegations and everything else that's happened in Hopkinton for quite a bit of time.
And yet his associate was the one looking at the documents.
They need an extra level of rigor, of attention that probably goes beyond a simple policy. And it's...
Can I just point out that we have, since 2020, paid this firm almost $1.3 million. This firm has been our counsel of record they're called Harrington Heep now. They were Maiaris in Harrington. Ray Maiaris was the partner. He's the same guy that negotiated the Legacy Farms host community agreement. I mean, these guys have been serving the town for years. And just since 2020, $1.3 million. We pay them to do everything for us. So, I mean, this idea that, like, you would have a junior woodchuck looking at this is just stunning to me. This is, as he even just said, this is the most consequential, one of the most consequential cases in the history of this town.
Judgment and its recognition by people that that's happening. So obviously, you know, while this document was distributed to many people, which it should be, to create more opportunities to identify a mistake, we have really, and this is not going forward from today, this is going forward from immediately discovering this mistake, you know, months ago, are making sure that multiple internal eyes are on every set of redactions.
By the way, I would like to point out that the PR agency, JGPR, John Guilfoyle, or however you pronounce their name, they had a copy of the unredacted document, which before anybody else did, which means that a marketing person at a PR agency saw the victim's information before anyone else did. I mean, it's just the standard of care that was applied to something so important. It's so egregious. I'm just completely perplexed that this is the level of professionalism that we can expect from Hopkinton's town council.
There are emails confirming that people have reviewed it, not just reviewed it for this or that, but for redaction. Because, you know, the way the human brain works, you can work in a document for one reason and not notice something else, particularly in a document this dense. So you need to confirm that somebody's doing it for that purpose. Another
basic
variable to this, and it's almost, in a way it's specific to this type of data, is making sure that multiple reviewers know the name of the survivor. And I know this may sound a little counterintuitive, but I can tell you that I did not know her name until this incident, and I didn't want to know her name because, you know, just like in the interview, when the human mind accidentally slips and says it, we really try to cabin that type of information so that if we're speaking in public or doing something, you know, you're actually minimizing the mistake of slipping up and saying it. But that has to be balanced against, you know, the person who's reading the interview outline or something else and being able to recognize, oh, you know, that name can't be in there.
So is he seriously saying that somebody should withhold the information so that they wouldn't know it? I mean, if that were the case, how would they know what to redact? I mean, that's absurd. I mean, we have attorney-client privilege. We're under no risk of anybody in that firm, presumably, disclosing anything confidential. I don't see that. That doesn't make any sense to me.
So there's that. There's, if we get something redacted from another source, more explicitly confirming the process that it went through.
And yeah, because you're the one responsible for redactions.
You know, and finally, it's making sure, I think, that, you know, counsel can do this and should be able to do this, but in high-profile cases, just also making sure that, you know, even if we get somebody from the town or from a different standpoint doing it, and this goes back again to, you know, there's a lot of lead-up legal work for the Loudermill hearing, and counsel are in these documents, and over a period of time, when you read a document that's lengthy or you've been working with a document, you can sometimes just miss things that are in there. And getting somebody who maybe hasn't worked with the document as much or something like that can give you a better sort of second check on that.
So I guess when we're talking about all the work that they're doing, it reminds me that as a result of this release, which was obviously preventable, we as the town, between the town and Harrington Heep, have had untold number of meetings. We're paying to clean this mess up. Harrington Heep is on a retainer. We pay him about $9,900 a month. So when you see him there tonight, he's not getting paid. We're not paying extra for that. Okay, that's part of our retainer. But for other work that goes above and beyond it, we do pay. And they send an invoice to us. So we're basically, they make a mess, and then we're basically paying to clean that mess up. I mean, it's absurd.
Doing that as well, I think, is important. And then finally, the other thing I alluded to earlier, there are just, going forward with a lot of public records law requests and a lot of other requests, it may be ideal for transparency to say, we've put this out there, we're now going to make it available to the public. That way people don't have to request it individually time and time again. But being more mindful that there's probably a core set of documents or a core set of matters where the information is so sensitive that that might not be the best approach to things. Because once it's there, people link to it or they do something else and it's out there. And it shouldn't be the responsibility of somebody who's going to a town website or something to be like auditing a document. Like, is there something in here that shouldn't be in here? That creates multiple failure points. It's not what we want to do. It's really making sure that the town is putting layer upon layer in these very important and sensitive cases to make sure that we recognize that, you can't go to one person and say, just do better the next time, because we're all human and we're all fallible. The way you avoid mistakes is building processes that are layered. They create checks, you put multiple eyes on things, different perspectives, and then even if something eludes that, what we put out there is to a small enough subset that we can at least minimize the potential consequences of that, which didn't happen here.
Again, there was no reason to put it out. I mean, no one had asked for this information. I mean, obviously, I would have asked for it following the meeting. I would have said, hey, I would like to know what you used. Merrick O'Connell, the labor attorney, like what were the documents that Nick Anastopoulos, the labor attorney, was referring to? What did the select board see? Of course, I would have asked for those things. But would Boston 20 for Fox 25 have done that? Would the Boston media have done that? Maybe, maybe not. I mean, they're there with the camera to report a 60-second story. I mean, how deep are they really going, right? I mean, HopNews, maybe the Indy would have done it, but who else? So I don't buy this heightened public interest and we were just trying to do the right thing.
But, that unfortunately, there's no other, to my view, magic way of doing this. I mean, redactions are tricky. There's a reason we put human eyes on them and typically not artificial intelligence or something, is that you just never quite know from context or whatever, and you need humans doing this.
Okay, here's what's not tricky. Control F, or if you're a Mac user, Command F, in a document that says, let me just search for the name of the victim. And if I find that in a document, I black it out. That isn't tricky. Everyone knows how to do that. So you don't need AI and fancy tools to figure out how to search a document and look for sensitive information. You just don't. It's basic stuff.
And that introduces human fallibility, which is where it's important to go through our processes, even where we made mistakes, which we certainly have, to improve them, to acknowledge when we make a mistake, and to promise to do better in the future. And so that's pretty much my comments on this, but I really just want to end again with where I began, and that is with, we're sorry. We messed up. And that
we, as in Harrington Heep, messed up.
Overstated. And I think that it's important that we own it, that we say it, and that we mean it. I definitely mean it personally. So if you have any questions.
Let me ask one first, just to start out. In my line of business, we do a ton of contract work.
So for readers that don't know, from left to right, Select Board member Amy Ritterbush, Joe Clark, Bryan Herr, Mary Jo Lafreniere, and Shahidul Manan. What they're going to do now is take a few minutes to ask Bertram about the issue, to make some suggestions on process, which some of this is pretty interesting.
We use comparison software.
Mm-hmm.
And that comparison software is looking for words all day long. They're either in the contract or in the contract in a different place, or not in the contract and it's supposed to be in the contract because we're sending red lines back and forth.
Every law firm has comparison software. It's stock because they do a lot of contract work. These guys do a lot of contract work for us. Real estate contracts, for example. You want to know what the turn of the document was. So you draft a version of the document, you send it to the other counsel, they make some changes, it comes back to you, and you can't trust necessarily the changes and the edits that were made, so you throw both documents into comparison software, and it tells you line by line, these are the words that are changed. This is standard stuff for every law firm in this country, practically.
Can't we do some kind of, I agree that you have to have multiple levels of human intelligence looking at these things as attorneys looking for, you know, the nuance that you folks deal with. But can't we add in also some level of technology that it also has to get checked off?
This is really generous of Bryan Herr because this isn't nuance. The victim's name is not nuance. It's not like, geez, maybe we should talk about this or we shouldn't. It's literally black and white. Don't put her name in the document.
What we send out?
That's certainly something we can investigate, and you know, it's not lost on me either. I mean, if we go back to the making the survivor's name known to more people, I mean, you can search a document for it.
Yeah, as we talked about, Control F, it's easy, find. People know how to do this.
And you know, in this case, that should have happened and it would have been found, but for the fact that most people didn't know her name because we were actively, in another sense, trying to protect against a different slip up. And so that's certainly a lesson learned here. And, you know, you're in the process of finding a new town manager, but we can certainly, whoever that may be, explore whether there's a software suite for that.
Why would we pay for that? Why would the town have to explore a software suite? Why wouldn't our attorneys do that for us? I mean, that's their job.
Budget, or would make sense, not just for the high-profile cases, but, you know, frankly, for the innumerable other redactions that the town has to do where you have less resources because it's not as high-profile.
This is not our job. We don't do redactions. They do redactions for us. That's part of their remit.
Could be something that helps.
Beyond the name, though, I think some kind of comparison search could also look for other personal identifying information, right? There's other stuff out there that led to the discovery of the situation further for many. So I think looking into that and maybe getting back to us on that possibility, I like the idea of a 2 or 3 tiered checkbox for various attorneys looking at it as a means to change the process. But, you know, there's technology for everything in managing documents, and I would think that we could figure something out here too.
Yep.
So with that, from my seat anyway, any questions, comments, Mr. Manning?
I think you covered most of the things that I wanted to hear today, and I appreciate your coming with detailed explanations and walking through the scenarios. It's definitely difficult and something we all feel terrible about.
I believe him. Shahidul, one thing that you saw at the Loudermill hearing, I mean, he was brought to tears, over the difficulty of that decision. I mean, he's a sympathetic guy. I believe that he genuinely feels awful for the alleged victim, the survivor in this case.
Especially for the victim. And I agree with Bryan. I also would recommend the new generative AI-related legal software. Those are pretty emerging technologies and much more robust in identifying this and comparing as well, and I can recommend some too. In general, I wanted to kind of emphasize on what you said, and I think you covered it well, just to understand. This is going to be a quality control process, or it should be. And the way you have described the layers and how many checks and balances, what we can do, what would be helpful is almost thinking of like a production line and having various layers of checks and balances as well, and audits, as much as you can make it foolproof, because as you rightfully said, we are all humans and fallible, and human error is something that happens. Statistically, it happens. So something of that sort, building a robust framework around the whole process, and at some point sharing it with us would be helpful. But thank you.
Yeah. I went over this in this document very carefully, and I trying to figure out how we're going to move forward, because 14 to 16 people saw this and missed it. That's a lot. And so I have a question. How does Labor Council and Kroll get involved in this? I mean, you're our town council. How did it get up to them?
Well, Kroll did the original investigation, and that, again, that's in a labor context. Whenever we have workplace issues, we will typically, because town council, we're all involved in this. If you're doing an investigation, you want it to be by at least an entity that has a level of independence. So they did that, and that's how they were involved. They were trying to both be helpful and I think to act appropriately in sort of protecting the survivor's name and some other details by sending to us. We didn't get it till it was done. In other words, we don't draft it, they do. Sending it to us in a way that was already redacted. As I said, that's, mistaken assumption number one is that we should sort of treat it as though it had never been redacted internally, would be the better process, rather than sort of looking at it and saying, okay, it's already gone through one level. Again, we still looked at it, but not with the rigor, not with the process. And that I acknowledge. So that's how they were involved. It was, Labor Council, Town Council, we were both involved in the actual hearing and proceedings. So, and again, many people got this. And so I would characterize that as many opportunities, but not many responsibilities to catch the error.
Yeah, I mean, that's right. The responsibility for redaction falls on our attorneys. Mary Jo is not an attorney, and she shouldn't be responsible for making sure that the alleged victim's name is not disclosed.
Words, the more people it goes to, the more opportunities there are that somebody notices it. But at the same time, just because it's going to these folks who may have a defined role or responsibility with respect to the process, if their responsibility isn't redaction, then it doesn't surprise me that they didn't notice it in a document of this length, this density, and as an attorney, I go through many documents like this, and I can tell you that we all like to think the human brain can multitask, but that's a fiction. You have something you're focusing on.
He's giving us a lecture about
with a responsibility or an objective.
I don't get it.
And it's very, very easy
to
just sort of not see the other things because you're focused on what you're doing. So, I want to be clear that, there's many entities named in that report, but not ones that necessarily had responsibility to redact it. Ultimately, there was an attorney in my office who reviewed it and missed it.
There it is right there. There was an attorney in my office that reviewed it and missed it. So, who was that attorney? Somebody who is not this guy. This guy abdicated his responsibility in the most important, consequential case in recent history of Hopkinton. Astonishing.
And, probably should have caught the name by the context and didn't. And that was a mistake. And there's, there should have been more layers.
E.g., I should have looked at it. I would have been the next layer.
I know I read it a number of times. And
I don't believe that.
And to tell you the truth, I don't know what her name is today.
Well, if you'd read it, you would have known. So did you read it? And what did you do? Did you read it a number of times or not? I mean, you would have seen it. It's right there.
The way the human brain works, and in my experience, that's perfectly understandable, and it wasn't your job.
I don't think so.
It's not perfectly understandable. I came up with a couple of suggestions, and one was try not to use Kroll again. But the other one was a machine to redact, a redacting machine, like you were suggesting, and someone to review. And I don't even know how practical this is. It's just coming to my mind to keep this from happening, is that we have an employee designated by the town to review all documents that may go to the press or be press-worthy.
So that's a really good idea. And what you'd call that person is an attorney who works for the town, not outside counsel like Harrington Heep, but an actual attorney. And if you look at what we've paid Merrick O'Connell, the labor attorneys, and Harrington Heep, the town council, it's something like $1.8 million since 2020. I'm pretty sure you could get a small and mighty legal team working full-time for the town of Hopkinton at Town Hall for less than $1.8 million. Oh, and by the way, that excludes the attorneys that the school committee uses. Murphy and I can't remember their name. We've spent another $500,000 with them since 2020. So, all in, what are we at? $2.4 million in 3-4 years? We could have done better with our own legal team in-house.
And that could be just, a futile thing to do.
No,
but,
it's a good idea. We should have our own attorneys.
That would help, I think, if we didn't put anything out until it was reviewed.
Yeah.
The press isn't going to like it because they want everything instantly.
No, we'd love it.
Yeah. No,
we would love it.
I
The press
agree
would
with
love
you.
it.
And I think
it would be
gets to,
faster.
Sort of my suggestion that we need, it's not, yes, the attorney should be able to do it, but there's value to having people in other roles who may have worked with a document less or seen a document less, also doing it as a second check against mistakes. Again, I'm not trying to evade the mistake that was made. I'm just trying to build processes that when a mistake is made, it's caught before it goes out rather than after.
Okay. Joe.
So thank you for going through that. When I brought this up, my intent wasn't, a witch hunt, go point fingers. It does not change anything for the survivor. The damage has already been done there. It's immeasurable. Can't even pretend to acknowledge that. But I think the thing that has been spoken about a lot is prevention moving forward, instilling confidence in the community that, if something happens and they need to go to the police or anything related to the town, that they have the confidence in doing that. And so I agree with a lot of these proactive measures. You talk about layered policy, and you also talked about just human error, right? Which I can totally appreciate human error, but in my mind, at the end of the day, and moving forward, when we think about like these layered policies, I look at us, from a town standpoint, and I think you summed it up very well as, opportunities to see it, but not responsibilities to. When I look at a legal document in my personal line of work, if it's a contract going out the door that can be signed and executed upon, if the numbers are wrong, that's enforceable, right? And that falls on our legal team at that point to take responsibility for that. So I'd like to see something that, again, hoping that no mistake is ever made again, but if we have multi-layered policies, again, you're going to have a human element to it. It's right.
I want to address this. I mean, Clark's making a good point about the human error. Sure, it happens. And I guess I would feel differently about this if we had our own attorney on staff, a town employee who worked just for us, and they came before the select board and they said, gosh, we screwed up, we were overworked, who knows what, so-and-so missed it, we screwed up. I probably would not advocate for the termination of that employee. I would say, okay, fine, it's a human. But that isn't what you're buying when you buy from Harrington Heep. You are buying a firm. You're buying attorneys, experienced attorneys, not just experience with the town of Hopkinton, but with lots of municipalities. You're buying paralegals. You're buying all kinds of stuff. Okay, you're buying a staff and a firm, and you're buying an expectation. And so in my mind, I'm like, no, this is not human error. This is organizational error. And that's where I have a problem with sort of just going, well, it happened. Let's all move on. Let's make it a little better. I don't like that. I think that somebody's head has to roll in this case. And that head should be Harrington Heep. They did not provide the town of Hopkinton with adequate representation. It was a low standard of care.
I think you agreed to that. And ultimately, I'd like to know that there's responsibility taken on that when we, hire a legal counsel to review things and they have that responsibility that's seen through. Because, again, hoping this never happens again, but that to me is ultimately where we need to get to. And again, I hope this never comes up again, right? But that's my thoughts.
Okay. Amy?
Yeah, I mean, first I want to say it's just absolutely horrific that the victim's information was not fully redacted and in a document released to the public.
This part to me is gross, and you're going to see why.
I want everyone to know that I was sick to my stomach, when I found out on Saturday, and I immediately contacted the town manager and the police chief, and they... Microphone, please. Yeah, yeah, and I immediately contacted the town manager and police chief, and they promptly removed the document on that Saturday, but...
All right, so here's the part she doesn't say is, oh yeah, I hit forward share to my personal Amy Ritterbusch contacts on Facebook and my Amy Ritterbusch for Select Board. There's thousands of followers. You know, we've released the documents. We've released it. She doesn't say that at all here. She doesn't. And by the way, she has not, since it happened, and she was called out for that, she has never once said something so basic, which is, oh my goodness, I'm so sorry for my part in this. Like, I feel terrible for having amplified that. Like, literally never shown a drop of empathy for this girl.
I've been very consciously trying not to talk about it publicly because although most news outlets, removed it in a day or two, I really do still worry that that document could be still found out there somewhere on the internet, because the internet is forever. And I really don't want the public to go searching for the victim's personal information. And so I felt that it was best to remain silent. That's my, and as well the DA, then the DA was looking into it, so we were.
I don't buy that. I think she just didn't. What else are you going to say? Other than I'm sorry, which would have been a human thing to do. She had an opportunity even right now to say, I am so sorry for my personal role in this. But she hasn't. She has never done that, which is why she's a subject of recall, which is why so many people in town are upset that she represents Hopkinton.
To be silent. But in regards to the suggestions going forward, I do agree it probably would be a good idea to look into software options because, we get public records requests for a lot of things. The police department, school department, and the town clerk's office, and it's a lot of staff work to redact things. So if we had software that would help with that, I think that would be good. Especially, I think when we start releasing body cam footage, it becomes a public record, but it will have to be redacted. So, and then redacting video is even more challenging than text. And then I guess I would like...
Body cam, another initiative put forth by Muriel a year and a half ago, no progress on. That's another story, obviously, but we have the body cams. They're sitting in a box on the floor at the police department, just so you know.
There's clear, they were clear on whose insurance is liable when things, if and when a mistake is made. I know the town has insurance. I know the lawyers, I'm sure, have insurance. I'm sure Kroll has insurance. But, the clarity on where the responsibility is. And then just the other thing I noticed, the select board, we received the documents about a week ahead of the Loudermill, but they were shared with...
A week ahead of the Loudermill hearing. That is 7 days before they were going to make a decision, ostensibly make a decision about Sergeant Tim Brennan's future. So they had plenty of time to review all of this.
A private Google or Microsoft folder that we had to authenticate in with our town account each time we viewed them. So I had the impression that they were not going to be released to the public. So I was actually really shocked when we arrived at the Loudermill hearing and I found that they were being released like at that moment at 5 p.m.
So she was so shocked that they were being released, and yet she turned right around and shared that on her own Facebook? I don't know.
On Friday, because had I known they'd be released to the public, I certainly would have asked more questions because I'm not trained in legal redaction. I don't know.
Why wouldn't you just, if you were really truly shocked, why wouldn't you have gone back to the town's PR or to the legal team and said, hey, should we have sent these out, or should these even be out there? Where was that? No.
I think we all assumed that the name would have to be redacted, but I wasn't sure what other pieces had to be redacted or not. And I think I did know, and I can't remember if it was then or after, that a newspaper had, I think the Boston Globe had been requesting some less redacted versions of some of the documents that had been released. So I know we were under a lot of pressure to release things. So anyway, those are my suggestions for going forward. I wish the select board had known when we were looking at them, so we could have, asked questions at the time.
Doubt she even read it because, as you'll recall in the Loudermill hearing, she came in with a canned speech, and she was shouted at by the audience because ostensibly the hearing is for the select board to learn and to listen to the testimony from both sides. But Ritterbusch came in already knowing what she was going to say and read from a canned speech that totally pissed off the audience, right? So she'd already made up her mind.
So, and like many others on the board, I work in the private sector. I've worked in the private sector for, I hate to say it, 40 years now. And HR is sacrilege. You don't touch HR, you don't expose HR, you don't discuss it in the elevator, you don't discuss it in the conference room. HR is private.
So I was a little confused by this at first. I think what he's really talking about is, he's looking at the Tim Brennan matter as an HR issue that obviously spilled into the public. But I think what he's really talking about is, the themes of HR. Like, you don't disclose medical history. You don't disclose personal information on your employees. You don't disclose. These are basic things that you just don't do as an HR best practice.
Whatever it is, it's private. In the public sector, I get it. I've done this for 20 years too, so that's a little bit of a different process. But there still should be some boundaries around what we, in the municipal government world, put out when it comes to human resources and people and their information, not just their information, but just the topics in general. Like, I'm all for transparency, but HR doesn't have to be that transparent. These are people's lives we're messing with. And I think it's important that we find a way to protect the people that we're charged with protecting and still be transparent. We don't have to put everything on the website. I'm sick of it. Let's put it on the website. Why? We don't have to do that with HR. We should not do that with HR. I don't know what the laws are around that, and I don't.
No, he's right. I mean, they didn't. There was no reason to do it. No one had requested it. They were just putting it out there.
The public, rules are about transparency and public documents and the like. There's got to be something else beyond this, though. Like, I can't imagine municipalities across Massachusetts or New England or the U.S. are putting up people's private information or even putting up topics that could include private information on websites and on social media sites. We don't have to put everything up. Someone said earlier tonight, I think one of the candidates for town manager, just because you post it doesn't mean you're being transparent. Mm-hmm. Okay? And I just think that I'm a little juiced about it. It's a hot button for me, and look where we are. Because we were so obsessed with being transparent that we just blew the whole thing up. All right? So I'd like to explore what policies can we put in place about human resources matters that involves posting on our website, posting on social media sites, posting whatever you want to call it, online. If there's anything we can do within the public, open meeting laws that are out there to tighten it up a little bit. I don't think we have to publish everything to be transparent.
I think I would agree. That's a lesson learned here. And, we don't have to post it under the public records law. We have to provide it if requested in certain forms or to the extent the law requires, but we don't have to post it. And so, I agree.
The difference between providing it and posting is that when you provide it, you just email it to the requester. Posting it is putting it out on a public website for Google and every other organization or whatever, every other person in the world to look at.
Have a policy, it's probably going to have some principles, and there would be some judgment exercise. I mean, maybe no HR, but there's probably other topics where there may have to be some judgment involved. But yeah, I think that, when we're all, it's one lesson learned swung us too far in the other direction, before where we responded to every public records law request in a timely fashion, 100%, no overturns by the supervisor of public records. But
by that's actually not true at all. We frequently have to remind them to respond in a timely fashion. They frequently do not respond in a timely fashion. I keep a log going of all the public records requests and just how many days have elapsed between when I requested and whether they respond, whether they actually fulfill it. I mean, that's not true.
Still sort of viewed as being less than transparent. The lesson learned erroneously was let's try to get ahead of it and put all of this out there. And we went too far. And I think this case shows that. And so I agree with you. I think we need to reassess that and try to find that happy medium.
Well, listeners, that pretty much takes us to the end of this. Look, to his credit, he apologized. To his credit, he fell on the sword through his firm. Again, I would reiterate my point that This is not just a human error. This is an error that had grievous consequences for the alleged victim. And it was an error made by a firm. And that firm is contracted to provide a high standard of legal care to the town of Hopkinton. And in this case, they essentially admit that they didn't do that. So more will be revealed about where that goes and where the select board and the new town manager takes that. But you heard at a minimum, what you heard tonight was some level of responsibility. We now know, we are on the record, or they're on the record with who was to blame for how this whole disaster happened. See you soon.